on, Mr. Cooper.
Thank you very much. I was just finishing off the point about the significance of the omission to sum up the evidence of Inspector McClure, and responding to Mr. Knox's submissions in that regard. I would just wish to provide my lords with some references as to this particular evidence. It's significant in my submission to highlight that firstly, Robinson, in his evidence, made plain that he went into the police station with Knowles, who had the gun, and that is to be found at 1563, line 20, to 1568. And thereafter, in order to illustrate the contradictory nature of the Crown's case on continuity and the very issue of the gun, the Inspector McClure contradicted Officer Robinson's evidence in this regard by giving evidence that it was not Robinson who brought in evidence, but Officers Rowley and Dams. That's R-O-L-L-E and Dams, and that is bundle page 499 at lines 18 to 23. And so it's significant. There was a divergence of account, but again, if one respects the fact that this was the custody sergeant responsible and experienced in recording exhibits and completing custody records, the fact that it was her evidence that she thought it was significant that she hadn't recorded a gun or the specific nature of the gun is an important point, given the practice at her police station that she was responsible for and her expectations in that regard. And so I submit that just as the Court of Appeal was right to conclude that the judge's refusal to summarise Inspector McClure's evidence was wrong because it was an important feature of the defence case, so too Evans was inviting the jury by his cross-examination to infer that Officers Burrows and Robinson were not credible witnesses. Remember that it was only Robinson who described Mr. Evans hiding the gun, and no other witness. So that there wasn't to say there was a corroboration of some of the critical evidence, and so these were important features for the trial judge to ignore. And I simply give these further illustrations as an example of the failure to give a coherent account of the defence case to the jury on these critical issues. My lords, if I can just turn now to the issue of the admission of the report of Higgs without the possibility of cross-examining him at trial, and the prejudice that caused specific to Mr. Evans. The background is that the trial judge interpreted section 122. This is at volume 1 at 4007. Sorry, this is electronic bundle page 4007. His interpretation was that it meant a desire by the defence to test the witness's evidence was insufficient to meet the interests of justice to call the analyst to give evidence. See 1894, lines 11 to 21. And Evans' counsel responded to that clear direction from the court to give specific reasons as to why she required Higgs to be cross-examined. And so, and it's important that she, as well as giving specific reasons, she also indicated that she had additional reasons. And so the judge then ruled that the prosecution should ensure Higgs' attendance if they wish to adduce his report, and expressly stated at 19152 that I believe it's in the interest of justice to call the analyst himself, and assured counsel for Evans quotes, "We will get him here for cross-examination. See bundle page 1919 at lines 17 to 18. So having ordered Higgs, ordered the Crown to secure Higgs' attendance as a live witness, the prosecution was then afforded time to make those arrangements or to show that it had taken reasonable steps to achieve that. See 1915, line 19 to 1916, line 6. And so on the 15th of July, the prosecution called evidence to inform the court about what attempts it had made. It became clear that the prosecution knew where he worked, knew where he was, had spoken to him during the course of the trial, but no further efforts had been made to contact Higgs after the judge's ruling on the 5th of July, and no efforts were made to secure his attendance by video conference. And so the judge made an express finding of fact. This is 2145, 2146, that the prosecution had not taken all reasonable steps to have Higgs give oral testimony. The judge then inexplicably reversed his earlier ruling on an unprincipled basis, admitted the report, stating the forensic report has great probative value for the prosecution's case, and it is in the interests of justice and fairness to the community at large that it be placed before the jury. And then this is 2147, lines 2 to 17. As a result of the failure of the prosecution to abide by my order under section 120, which requires Higgs to provide oral testimony in this court, I make the following order. The forensic report of Higgs is admissible in evidence under 120, subsection 6, without calling him give evidence. And the simple point is that nothing had changed between his ruling on the 5th of July, when he positively ruled it was in the interest of justice to give evidence, and the 16th of July, when he ruled the opposite, apart from the judge finding in favour of the defence that the prosecution had not made reasonable efforts to secure. So where the Crown had stated in its case at paragraph 71.2 that he could not be found, that was factually mistaken. I believe that the Crown has now fairly conceded that,
yes. Yes, that's right.
So the last contact with Higgs was on the 27th of June. And so it was on that basis, as I already characterised it, irrational and perverse. Now, in any event, if reliance is being placed on fairness to the community at large, then the interests of a fair trial are part and parcel of that consideration, and the importance of avoiding a miscarriage of justice. So, as a consequence of what might be simply characterised as a decision not to make any further attempt to get him there by any means, Evans was denied the opportunity to cross-examine Higgs about any aspect of his report, including by the readily available possibility of video link. And so Thompson was brought in his stead. And the trouble with Thompson was he couldn't deal with the points that were put to him. And so if I can just give my lord some references. When Evans, this is 2323, lines 15 to 25, he could not say whether or not the magazine for the relevant firearm was tested or whether a different magazine had been used. And he didn't know what method Higgs had chosen to use. He, at 2308, line 18 to 2309.6, he couldn't say what had happened to the test ammunition used for comparison, but agreed that it should have been preserved. 2315, line 13 to 16, he couldn't say why Higgs had come to the conclusions he reached from his report. And so one sees already that there was a very serious attempt to ask the very questions that the Crown is wrongly asserting were never in issue and would not have been raised with Mr. Higgs. And one sees from the actual cross-examination of Thompson precisely that those points were made diligently on behalf of Evans, and in fact the other counsel also, 2296, line 24, counsel for Stubbs elicited that Thompson could not say whether the proper protocols had been followed when Higgs conducted his analysis. He could only say what ought to have been done. At 2292, line 2 to 2294, line 6, it was pointed out that one protocol was peer-reviewed because mistakes can be made, as we know from the equivalent cases in this country. He couldn't say whether these results had been peer-reviewed. And then under cross-examination from Davis, bundle page 2329, line 19 to 2331, line 26, he did not know what Higgs' notes said and didn't know if they were in the file that he had. So he hadn't even looked at the notes, which were the explanation for the analysis that he was purporting to explain and understand and testify to, which was a considerable failing and demonstrated really what a poor substitute he was for the real witness. And at bundle page 2335, lines 1 to 26, it's notable that the trial judge refused permission for there to be for Thompson to check the file that he brought with him in relation to the issue of the testing of the swabs. Now, it's obviously concerning that in a case that turns on whether the police have planted the gun, whether they're credible, whether they fabricated this line of evidence, that Evans has made plain that he didn't possess a gun or fire the gun, and therefore would not, by logical extension, would not have any gunshot residue on his body or clothes. That there was this glaring omission to test precisely that. And so if you look, my lords, look at the report of Higgs at bundle page 3938, at number 4. Terence Higgs states that no examinations were conducted on the articles of clothing that were submitted. So they were submitted for testing, but they weren't examined, whereas the swabs weren't even submitted at all, as well as not being examined. And so it's rather odd that such an important line of inquiry was excluded by the trial judge, and it was deemed to be some form of protecting or assisting the defence to prevent Evans from establishing these points. And so the prejudice to Evans was clear in a case that was already fundamentally weak and riddled with inconsistencies and evidence that ought to have been excluded, where he was then unable to test the police internal analyst who attributed the casings found at the scene to the gun that he denied being in possession of. Now,
well, what exactly would the testing have consisted of? I mean, the position was clear that there were no tests done on the, well, so far as the jury was concerned, no tests done on the clothing, no examination of the swabs. That point could be made perfectly clearly to the jury, couldn't it? Didn't require Higgs to confirm that he hadn't conducted the tests.
Well, the judge chose to excise those parts, so the reverse happened, and there was no possibility of drawing those points out. But this was, my lord, this was a case where Evans was consistent and clear throughout that something had gone forensically wrong in the attribution of the gun to him, right from the start at the scene to the end of the testing. And it was important for him to demonstrate what precisely had happened factually, that had gone wrong, as opposed to simply asserting the matter. And he wanted to do that through understanding why it was that it's relevant, for example, why it was that the clothing was not submitted, sorry, the clothing that was submitted was not examined, and why a decision was made not to test the swabs at all. These are all material parts of the police investigation which were important.
What beneficial answer could have been obtained? I mean, surely it was perfectly open to counsel to say to the jury, look, in a case like this, you would expect the clothing to be examined. And if it was the clothing of the gunman, you would expect firearm residues to be found in it. Here, we have no evidence of firearms residues at all. And thus, that must cast doubt on the attribution to my client of being involved in the shooting. What more did you need from Higgs in order to make that point?
The defence case was that this was a deliberate fabrication by the police.
What was a deliberate fabrication?
To attribute the gun to him in the first place, and therefore the various steps in the prosecution evidence that enabled the Crown to present a case that this was his gun all had to be tested by Evans, and it's also right to point out that. Although the Crown say that the defence could have conducted their own examination of this material, firstly, the issue arose at a very late stage in the trial. It wasn't as though there was advance notice. So this was during the course of the trial that the matter came up. And at that stage, it's our understanding from counsel in the Bahamas, and obviously Mr. Knox and his solicitors will correct us if we're wrong, but that there are no independent firearms examiners or analysts in the Bahamas. That they're only those attached to the police force, and so there was no independent firearms examiner available to the defence to test the material at that point. The timing is significant, especially when Evans was entitled to believe he had the opportunity to test this evidence for quite some time when the judge ruled in his favour. But the important point, yes.
Yes, Lord Burrows.
Just because we've got it open now, I'm looking at the actual report of Higgs at page 3938. I just want to be clear, because I think you've told us, and we were indeed told by Mr. Knox, that parts of this were excised by the trial judge, I believe, having made the decision to allow this evidence to be admissible. And I think Mr. Knox was indicating, well, it all becomes completely coherent because having found that Mr. Higgs was not going to be available or wasn't coming, there therefore had to be some editing out of the report. Now, which parts were edited out?
Yes, well, my lord, my understanding is that the references to the swab, to the testing of the swabs and the clothing was edited out. I wonder if I can come back to my lord with a reference to that.
Thank you very much. But that was done at the point at which the trial judge was taking the view that this evidence was going to go in. It's not as if that decision was made a long time in advance when they were still working out whether Higgs was going to come or not. So it's correct, isn't it, that the submission of Mr. Knox, that this was all quite rational, that having decided Higgs wasn't going to be available for cross-examination, parts of the report were taken out. Well,
my submission, my lord, is that aspects of the report that were excised were favourable or relevant to Evans's defence, and so it wasn't a step that assisted in the fairness of his trial, because his counsel, Ms. Farquharson, made plain that these were precisely some of the areas that she wanted to test.
Well, can you give us a flavour of the questions that would have been asked and the submissions that would have been made to the jury had answers favourable to Mr. Higgs been obtained? I mean, at the moment, it's all very well to say, oh, well, this was material that she wanted to cross-examine on. I mean, do we know what the line of cross-examination was going to be?
Yes, my lord, the starting point was testing the methodology and the correctness of the approach of Mr. Higgs, and whether the protocol was followed, and one sees that from the actual questions that were put to the substitute Thompson, that there was a complete lack of clarity, and certainly no positive evidence to show that the analysis was conducted in accordance with the correct procedures. And ultimately, this was evidence central to the Crown's case, which Evans was entitled to probe and to test and to establish was not reliable. And had Higgs been there and she succeeded with that line of examination, then the reliance that could have been placed on that evidence would have been undermined. And so that opportunity was denied the defence for Evans.
I'm still finding it difficult to understand precisely what sort of question would have been put to Mr. Higgs and with what purpose. I mean, it certainly doesn't assist me, and it may be my fault to have resort to generalities and saying, you know, well, she was entitled, this was central to the Crown's case. Exactly what sort of question would she have been putting to Mr. Higgs, and what did she hope to obtain by it?
Yes, well, one example would have been, my lord, that the starting point would have been whether the casings attributed, essentially what the report establishes that the Crown seeks to rely upon it for, are that the casings found at the scene matched the gun that was said to belong to Evans, and the counsel for Evans would have set about showing that the conclusions that were reached, which was affirmative to that proposition, were not reliable because the correct methodology was not employed by the analyst at the time, and as I say, the questions that were put to Thompson demonstrate the failings or the lack of adherence to those protocols, so far as Thompson is aware, and so there's instead a complete question mark over whether what in fact happened took place because of the inability of Thompson to answer those points, and so this was important in the context of, although the Crown have today described the bullet casings having been essentially found at the location where Ambrose was shot. The reality is that the casings were found in a number of different locations at the scene, and really that would be the starting point. And so if I can just, would it assist if I just took you to that now, or perhaps I can continue with the...
Well, I think you better continue with your submissions, but you have been alerted to my concern, at least, about a lack of precision as to which questions would have been put and how the absence of Mr. Higgs disabled the effective presentation of Mr. Evans' case. But do continue with your submissions, and you can return to that if you feel it necessary.
Well, my lord, if I can just continue to answer the specific question you posed first. I've explained already that the methodology of Higgs would have been challenged, and if that had been successful, then the conclusion that he reached would not have stood, and that evidence would not have been in a form that would have been relied upon by the Crown in support of the conviction. Yes, the examples I've given already of the questions put to Thompson illustrate the type of questioning that was in fact asked in that regard. Insofar as the other matters that Higgs was responsible for, it's clear that he was charged with the examinations of the clothing that were submitted, and he would have been asked why it was that the clothing that was seized from Evans was not examined after it had been submitted, why it was that the clothing that matched Campbell's description of the additional shooter beyond Davis and Stubbs, the black jeans and the red top, was not submitted for examination, was returned and ultimately lost as evidence, and why it was that the swabs were not submitted for examination, and it's really the entire process, whether there was a degree of due diligence and professionalism as to the approach to these fundamental exhibits in the case, where Evans was plain that his case was that at no point had he ever touched the gun, let alone fired it. And of further relevance is the fact that the gun wasn't fingerprinted, and that would have been a further question to raise with Mr. Higgs. Now, my lords, I was just about to explain that it was said, I submit it's wrong for the Crown to assert that the bullet casings were all found at the scene of where Ambrose was shot, that are subsequently attributed by Higgs to Evans. If I can give my lords a reference to page 278, volume 1, at line 1 to 279, line 1. The evidence of Scott was that Ambrose was attacked a few feet from the fence close to the road, which was about 35 feet from the entrance to the club where Scott was standing. Then at volume 4, 1235, Officer Roll, R-O-L-L-E, states that two of the casings attributed to Evans, that's KR5 and KR6, were found right at the entrance to the club, and therefore at least 35 feet from where Ambrose was described as being. And the other casings were found, quotes, not too far from the western wall. They are KR2 and KR3, and by the entrance gate to the establishment, that's KR4. Then Campbell describes Ambrose as being attacked next to the black truck that was parked on the lawn by an old building and a fence and scooter rental place. He doesn't mention the western wall or the entrance gate, and the reference there is bundle page 359 at line 14 to 360 line 10 and 361 lines 26 to 29. And again, from his evidence, the relationship between the location of the casings in Campbell's evidence is unclear. So what I submit is that the casings were found at the scene in 4 separate locations. No one is able to say that, from the Crown's position, that the casings were found next to the body. 2 were at the entrance to the club, which is not where Ambrose was attacked, according to Scott. So to say the casings were found next to Ambrose's body is in my submission, a misrepresentation of the evidence that was called. And that is the genesis of the casing, the bullet casings that Higgs subsequently examined. And so, my lords, another way that the Crown approached this issue by way of testing it was whether the remaining evidence the jury would have been considered would have been insufficient to satisfy themselves that Evans was part of the killing on Ambrose or the attempted killing of Scott. Even if he was in the possession of the firearm. And so one recalls that there were at least 4 men with guns seen by the witnesses, not all of whom were alleged to have attacked Ambrose. So the fact that the gun alleged to have been discharged at the scene was attributed to Evans was a critical piece of evidence. And yes, the .357 caliber ammunition is a standard type of ammunition used by the Bahamas police force, who are issued with those .357 caliber revolvers. And coupled to that point is really just that this is a case where the basic ID evidence was insufficient. It was too weak to uphold the conviction on itself, and therefore the evidence of Higgs carried a special importance on the particular facts of Higgs' case, which the trial judge recognised and the Court of Appeal recognised. So I do underline the fact that a negative result for the gunshot residue, which wasn't sent for testing, would have really destroyed the Crown's case against Evans, and that was a legitimate line of inquiry for counsel for Evans to put to Higgs, just as it was in relation to the clothes. And there were no other witnesses who gave evidence about the examination of the swabs, because Higgs was the examining officer. So the only way counsel for Evans could untangle this and find out what happened to those swabs, why they weren't tested, was by asking Higgs. And one can see from Thompson that he was ill-equipped to deal with any of these issues.
Yes.
So whilst Thompson gave evidence as to what type of tests Higgs might have carried out, he could not say what tests were carried out by Higgs and why, nor whether the protocols were followed. And he wasn't familiar with the notes. He didn't understand what they were about. He hadn't read them.
Well, we've been over this ground already, haven't we, Mr. Cooper?
We have. I'll move on, my lord. Ultimately, my lords, I rely upon the reasoning of the Court of Appeal at 3390, which was the section 120, and the ability. This is at 3391. The ability to introduce a prejudicial and disputed report without giving an accused the ability to cross-examine the maker of the report is a discretion that has to be very carefully exercised, and the defendant ought not to be deprived of that opportunity to examine the analyst as to the cogency of his evidence unless there are compelling reasons. And the specific finding, the court found the reasons advanced by counsel were for counsel for Evans were credible and accepted by the trial judge, and then the judge's finding that they'd failed to take reasonable steps to bring him to court. And so, in conclusion, I submit that the Crown has failed to establish that that it was in the interests of justice to deprive Evans of the right to cross-examine this particular witness. There were no such exceptional circumstances that arose on these facts, and there were a series of good reasons that justified that line of examination.
Yes.
Yes, and yes, if I can just, yes, if I can just refer, my lords, to bundle page 1206 at line 16. one sees here that the counsel for Higgs, Ms. Ferguson, made plain that when there was the fact that she had a genuine reason for the calling of Higgs to give live evidence by saying we would have to speak to what we need, because if they are now to be our witnesses, before I embark on the defence of Mr. Evans, I need to interview and speak. So she was quite serious about wanting to question and engage with Higgs, were that to be a necessary step. My Lords, in summary, I submit that as a matter of basic principle, one has to approach this from the starting point that the defence have the right to test the probity of this particular aspect of the prosecution case, and I rely upon the case of Grant and support that dispensing with a witness for cross-examination can only take place in limited circumstances where sufficient safeguards are in place. Here at bundle page 1879, it's right to highlight that counsel for Evans stated when tested on what she wanted to ask Higgs, that quotes, I ask his lordship to bear in mind as well that the issue we're dealing with is quite significant. We are talking about testing of projectiles, swabs for gunpowder residue, which is quite crucial to the issue that is before the jury to decide, my lord. So it's quite significant. So it's not, she doesn't have to repeat that point more than once. She made plain right at the outset that the issue of the testing of the projectiles was a matter she wanted to question Higgs on. And that, in my submission, was sufficient, although the focus later shifted to the testing of the swabs and so on. That was enough that she made plain her case to the court as to that important line of cross-examination, which is then corroborated by the actual cross-examination of Thompson.
Yes.
Yes. And so one sees that 2303, bundle page 2303, 2315, 2321 and 2327, that the methodology and the nature of the examination and whether it had been properly carried out was directly in issue and tested as best it could be in the circumstances. So, my Lord, I submit that the Court of Appeal reached the right conclusion in relation to Evans, albeit that they may have been mistaken in relation to Stubbs. On Evans's case, they reached the right conclusion for the right reasons and understood the particular factual basis that Evans was justified for the fairness of his trial in testing the evidence of Higgs, which in fact covered a number of essential issues to his case. My Lords, I referred at the beginning to the assistance of the judgment of the dissenting judgment of Crane Scott, and I gave you the reference to that. I would simply highlight that there are a number of different parts of that judgment which are relevant to a number of the points that I've made. Yes, it's the bundle page 890 that the judgment begins, and at 348. Sorry, this is internal pagination 348, which is bundle page 913. the judgment sets out the summary of the reasons why she would have upheld the appeal, which I adopt for the purposes of these submissions. And firstly, she states that the trial judge failed to protect Evans' interest by giving a timely and comprehensive direction and warning in relation to the record of Stubbs' interview. Secondly, having misdirected juries a number of witnesses who the Crown alleged identified Evans, he failed to retract that misdirection in a timely manner. And then when he did so inadequately. And then in paragraph 349, when dealing in his summation with the appellant's records of interview, the judge effectively lumped all three of the appellant's statements together in so doing. I've taken to my assessment. I just point out that really a lot of these points are picked up on and specifically upheld in that dissenting judgment. Those are my submissions in response to Mr. Knox. My Lords are aware that we have a cross appeal, which only arises if Mr. Knox were to succeed in his case, and I set out the submissions in that regard in writing in the respondent's case. Some detail. We'd need permission, first of all, to cross appeal on the firearms offence. This would only arise were there to be a retrial ordered, were the appeal to be allowed by the Crown, and then a retrial ordered. But I adopt my submissions as set out in the respondent's case in support of that. I wonder if I could just ask for a moment just to...
Yes, of course.
Thank you. Sorry. Sorry. Yes, my Lords, yes. My Lords, it's the reference is 2147 to where the trial judge excluded portions of Higgs's report, but he didn't invite any submissions on it at all. He simply made that part of his ruling. So we have a further point, which is that he reached that decision without giving any consideration to submissions from counsel.
Yes.
And in that sense, well, there was an issue of procedural unfairness to Evans in not being invited to contribute to the rather significant decision taken as to edit those parts of the report.
Yes.
Yeah, so 2147 around lines 24 and 27.
Yes.
And my Lord, just an obvious point in response to Mr. Knox, which is that the Crown, in presenting its response to the appeal of Stubbs, rely on Campbell's identification at the identification parade to demonstrate that he was picked out because Campbell said, "I recognise this man to be Stubbs," effectively. And then at the same time, they rely upon the very same identification for Evans. And obviously, as a matter of basic reason, it can only be one. The Crown can't have it both ways. They really have to elect which one they purport to rely upon. But my position is clear that there is a significant distinction in identification cases between recognition evidence and picking someone out who you've seen in isolation on one occasion. And what Campbell purported to do in my submission was to recognise Stubbs, and it's clear that his position was that it wasn't recognising at that point, and it's important, therefore, that the independent inspector did not deem that to be a satisfactory identification of Evans.
Yes.
Yes, my lords, I don't know whether any specific points I can assist with that have arisen.
No, not unless some of my colleagues want to raise a question. Well, I don't see any indication that anyone does. So thank you very much indeed, Mr. Cooper. Does Ms. Matthews wish to follow?
She's indicated no, to the contrary.
Thank you very much indeed. Now, Mr. Knox.
My lords, can I just take these points quickly, I hope? First of all, it may not matter very much, but in my submission, the Court of Appeal was not unanimous, or not in any material sense, in allowing Evans's appeal. I showed you this morning the passage at page 3432, para 288, and I'll just read it out again. Well, it's where the President says, the majority, in my judgment, have engaged in acts of fantasy to reach that conclusion. And this is the important point. The case for an acquittal in these circumstances cannot seriously be advanced. Indeed, if the report is admitted, he plainly thought it ought to be, the provisos should be applied and the appeal dismissed. So it may be that formally, it doesn't matter very much, maybe formally, the President hasn't said, I'm going to stand out as a dissenter. On the other hand, his reasoning quite plainly is that the report should have been kept in, and that being the case, the proviso should be applied. And I say that's the right approach. On the miscarriage of justice point, my learned friend, I should obviously reiterate that we do say there has been a substantial miscarriage of justice in this case. It is an important point, the inconsistency of verdicts and also the Court of Appeal interfering with exercise of discretion. My learned friend, Q2 Buxu, my lord, there's only one point to note in that. The board does note that this is not a rigid rule, that it requires some sort of important error of law, and that the prosecutor and the board does give permission from time to time to the prosecutor to appeal. It refers to three relatively recent Hong Kong cases which had errors of law involving import and export statutes and things like that. But my lords, it's not a rigid rule, and I submit there's no question here that should stand in the way of the appeal if we are otherwise right. My lords, can I deal now with the casings point and matters to do with the guns and the tests? My lords, the significance of the finding of 5 .357 casings, some right by the entrance to the club, others a little further away, is that it shows that the person who was firing the gun was one of the attackers, even if he didn't actually fire the bullet which killed the deceased. This was a case put on the basis of joint enterprise, and it's inconceivable in real life that Evans could have run a defence along the lines, well, I must admit, I was one of those chaps who was firing a gun, but take it from me that I was actually nothing to do with the attack and had no intention of assisting the attack. My lords, he didn't run that defence, and it would have been a wholly implausible one. So I submit the fact that the location of the casings is not all by the body is neither here nor there. The important point is they're all at the scene. I should also emphasise Campbell's evidence tallies exactly with Raleigh's evidence as to where the casings were found. By 2 of them at least, he sees firing of the guns just outside the club, and we know that two of the .35 casings, or at least one, was found there. I think 2 actually. My lords, as far as the editing of Higgs's report is concerned, you can see the full report attached to the respondent's case in Evans. And that report, I think I'm right in saying, is at, forgive me, my lord, I've lost the reference. Quite far. It's at tab 3, at 3844 to 3847. That's where the report is. And my lords, you can, I'll describe basically what happened, but I can just give you the references to where you can find out a bit more about the precise nature of the editing. in our case at paragraph 63, 3866, that's the other case. That's the case against Evans. Page 3866, paragraph 63, we summarize, forgive me, I think it's six, yes, that's right. Forgive me, it may be 3865. You'll see paragraph 62. The judge gives us a ruling on the bullets and so forth. Evidence's counsel asked for certain things to be excluded from the transcripts. And so, my lords, she's not wanting things to be kept in, but wanting things to be kept out from the previous transcripts. Various argued that chain of custody, and then at the top of 3866, you can see how the judge describes how he's going to leave the report. We're going to proceed to put in this report and take out the times relating to KR7, that's one of the bullets found in the body, and HG1, that's another bullet found in the body. My lord, that evidence got excluded on quite different grounds. These are the two projectiles, i.e. in the body. All the items related to the clothing, both for Andrew Davis and Clinton Evans, that were not Sikh, for which no examinations were conducted on those items. And the suggestion is that everything in relation to Germaine Poitier, because it is irrelevant, I didn't include that because it's irrelevant. Those are to come out also. So that's what was to come out. And if you then look at the, you get a pretty good idea of what that would be by going back to page, whatever it is, 3844, I think. 3844, my lords, I think what eventually comes out is, I think RK1 stays in, maybe GR1. I think GR2 may come out. I think those are the two bullets found in the body. Don't think RK1 and RK2 stay, and then KR1 to 6 stay in, going over the page, and then everything else, which is also Keith Roddy, everything I think from KR7 down to item 32 comes out. And I think also HG1 comes out. And then examination results stays in. I'm pretty sure, my lords, all that does indeed stay in, including the discussion, and thereon. My lords, I believe also what you see is paragraph 4 on 3846, that stays in, but my lords, I'm not 100% sure. But the way you can, as it were, check, double check, is by the calling of Higgs, and that, my lords, Higgs's evidence is called, and I think we described this in our case, at 3866. 3866, paragraph 63, and then Thompson reads out the relevant part of Higgs's report. And so, my lords, you can see precisely which part of the report goes in by looking at these references. And I think, my lords, I'm pretty sure it's along the lines I just mentioned. Whether or not it's absolutely along the lines, I'm not sure.
Yes, well, I think the gravamen of the case made by the respondent is that there's going to be a challenge, or there would have been a challenge to the methodology employed by Higgs if he had been rendered as a witness.
Yes.
And that was proved to be impossible. Thompson really wasn't in a position to provide satisfactory substitute, and therefore Mr. Evans was denied the opportunity to discredit Higgs in his interpretation of the casings on the bullets. I mean, what do you say then?
Well, my lords, can I just take matter back one stage further? Because the actual objection and the reason, rather, for wanting Higgs to turn up, and this is what I was mentioning yesterday, the reason for wanting Higgs to turn up to give all the evidence, so he could be asked about the things which he had not examined.
Yes,
no request to him. So that's the underlying point. And my lords, can I just mention what that point would have gone to? That would have gone to a point which could have been made anyway, which was namely the police were lying when they said that Evans fired the gun and therefore had the gun. So one, what you might call element of the defence is Evans didn't have the gun. That's why there's nothing on his clothes. And that's why we want Higgs to come along to explain why he didn't do an examination on the clothes. To which our answer is quite simply, well, that point's available to be made in any event. It's an obvious point. No examination was done on the clothes. That's it. And so that's the answer to what you might call the absence of testing on the clothes. You could always make that point in any event. The second point is that there might have been a challenge to Higgs on the basis you didn't carry out a proper test and you didn't know what you were talking about when you said this was a .357 Magnum casing and things like that. That would be the other notional attack. Now, as I've said, they didn't want him to attack him on that basis, so the point goes. But the second answer I make is that you could ask Thompson any question you liked about the size of casing and the gun, any question at all. So the fundamental point was always going to be there for the prosecution, namely, at the very least, you've got Thompson there to ask about, was this a .357 Magnum casing? That's obvious. We've got the exhibit. You can ask him that. Secondly, you can ask him, was that a .357 Desert Magnum? You can ask him that. So there's no prejudice in asking Thompson those questions rather than Higgs. And my lords, they didn't actually probe on that point for the obvious reason that there was absolutely no two ways around that conclusion. The one thing which they might have been able to press with Higgs would be the tests. Tell me what tests you did. Now, in my respectful submission, he would no doubt have given his answers. These are the tests I did. But my lords, one asks rhetorically, what possible disadvantage were they at in having Thompson there, not being able to say precisely what the test was, rather than Higgs there saying this was the test I did? And in my submission, there's none.
Well, unless Higgs conceded it, which is technically possible, that he had carried out or he'd performed the wrong methodology.
My lords, it is just possible. But my lords, there he might have conceded it. But my lords, the difficulty with this is, if I may say, beyond, it's wholly implausible. And what is more, my lords, the file was there to be examined. They could have taken a look at all Higgs's notes and then said, well, I see he obviously went wrong there. My lords, there is also the other point. These aren't particularly complicated tests. The actual test isn't complicated. You might have to interpret the result by looking at the bullet and the casing fired, but even that's not that complicated. So, my lords, I do respectfully submit this is not a case where there's any prejudice at all by not having Higgs there as opposed to Thompson. That's what it comes down to. Especially as they didn't want him there for that purpose anyway. And that's really my prior point. Yeah. My lords, I can see this much. Supposing what they'd said is, before the judge on the voir dire, is we don't trust that man Higgs 1 inch. He's got a terrible reputation. He doesn't know what he's doing. We want to test, we want to put lots of questions for him. Well, that would have been a good reason for the judge to say we'd better get him along, or for saying, if that's what you want him for, I suppose we better exclude him. Because you can't now pursue a line of examination which I can see you've said you want to pursue, and possibly there's something in it. But just as I want him there, without saying that, my lords, I submit the judge is entitled. My lords, it all comes to this. The judge has got a difficult decision to make. He has to protect the interests of the public and the community. He has to protect the interests of the accused. He's entitled to take into account the reasons he's given. And if he's not given a specific reason, along the lines, I want to test Higgs's evidence on the tests, he's entitled to say, well, that's that. You deal with Thompson. So that's what it comes to, my lords. It all ultimately turns on that point. Why did they want Higgs there? Did they make it plain? But I do say there's no prejudice anyway, because there's no doubt about what the casings were and what the guns were. And once you have that combination, I submit that's the end of it. With respect, that's really the end of the case as far as what the jury, a reasonable jury, would do. My lords, can I just mention this? The judge does remind the jury in his supplemental summing up at bundle 2, 643, that from what he had, the judge reminds the jury of Thompson's evidence that from what he had read of the examination results himself, he couldn't have come up with conclusion number 4. In other words, what Thompson accepted was if you look at the report at page 3847, this is one of the conclusions, and what was put to Thompson was take a look at, as it were, 3847, and take a look at paragraph 4, conclusion 4. Laboratory comparisons were conducted, and it's the finding of this examiner that casing M, Cal1, and projectiles A and B, that's 7 and HG, I think HG would have been excluded, were all discharged by the submitted .45 pistol, serial number raised. Casings N through R, KR2 to 6 were all discharged by the .357. So that's his conclusion, and that's obviously a conclusion he's formed from doing the tests. And the point made by the defence was, well, if you looked at the report all on its own, you couldn't, as it were, see where the justification came for that. You'd just be told, well, that's my conclusion. And the steps leading up to the conclusion weren't there. So the defence was able to make that point. And Thompson said, well, yes, looking at the report, I agree, I can't move from one particular part of the report to that conclusion. Because, of course, the report doesn't specify all the particulars or exhibit, for instance, photographs. And that was the point made by the defence. But, my lords, all that helped the defence. It was not a prejudice to the defence. It's positively helpful to them that they've got, as it were, only someone coming along after the event to say, yes, I myself can't tell. But they would have got that answer off Higgs, and then Higgs would have said, yes, but I'm going to tell you something else, and I've got my notes with me. So it doesn't, in my submission, go anywhere. And the judge does remind the jury of that point. My lords, the next point my learned friend makes is about what you might call an election on identification. I can't say one at the same time, I've got, as it were, Campbell's 30th of March 1999 statement stands both as good evidence that he identified Stubbs and that he identified Evans at the same parade, because after all, he says he only identified 2 people, not 3. My lords, I accept that point as far as it goes, but it doesn't go to the question, how should the judge have exercised his discretion in admitting, in allowing Campbell not to give evidence? In my submission, the answer to that was, well, there's obviously some confusion here, but there is a basis for saying Campbell did pick out the man at number 2, obviously, because he says number 2. And there's also a basis for saying that he has recognised Stubbs, because he's managed to pick out, or he thinks he's seen someone called Dyer of Richland Park. No doubt there'll be a lot of cross-examination on those points, but it wouldn't, in my submission, be right to the judge to say, I'm going to kick the case, I'm going to kick the evidence out just on that basis. My lords, as far as the identification directions are concerned, this is not a fleeting glance case on Campbell's part. He says, at least, and no real challenge to it, that he was able to see the events for about 5 minutes. My lords, my learned friend suggested that the directions, the identification directions, didn't sufficiently distinguish between the 3 accused. My lords, that is not, in my submission, a fair criticism. The first direction, first what you might call general direction on identification, is from pages 564, line 30, 565, line 16. And that is a general direction. on identification evidence, and in my submission, it is perfectly reasonable to give what you might call one direction in relation to all three accused, because the same point applies whichever witnesses we're talking about. And then from pages 566 to 568, essentially, the judge discusses the directions in the context of Martin Scott's evidence. And he does so at that point in relation to Stubbs and Davis. Again, I submit there's nothing wrong with that. And then he reverts at 568 to 571, where he gives directions which apply to all three. My lords, I submit no criticism at all can be made of those directions as general termable directions, and doing it the way the judge did. My lords, I do respectfully submit that those directions were sufficient to tell the jury that they had to be careful about the identification directions. My lords, the next point is about Officer McClure, and my learned friend says that there was a contradiction between McClure's evidence to the effect that Ryan was the officer who brought in Evans to Central Police Station, and Robinson's evidence that it was he who brought in or arrested Evans and took him to the police station. My lords, that's the point that my learned friend makes, to which I say, first of all, this. One must bear in mind, this is a case where Evans didn't give any evidence himself, nor was any of this in his interview statement. Second, Evans's own case in cross-examination of, I think, Robinson, was that Robinson was indeed one of the men who picked him up, and indeed he and Robinson had got into an argument with each other. So it's obvious from that that he accepts that Robinson was the person who, on or after arrest, was in an argument with him. My lords, the reference for that is at paragraph 21 of the appellant's case against Evans, at page 3853. So there's no doubt that Evans accepted that Robinson was one of the people chased after him. The issue is whether he was carrying a gun. And my lords, in any event, as I said earlier, the prosecution's own evidence was that it did not take the gun itself into the station. So, my lords, one asks, with respect, where would a direction about McClure's evidence take the defendant? In my submission, it just wouldn't go anywhere. And you have my submission from this morning. It would have to be counterbalanced by the, as it were, the damaging parts of McClure's evidence, which came out in cross-examination. My lords, this, I think, the next point is what you might call the insufficient differentiation of, between Evans and the other defendants. My lords, the evidence against the three defendants overlapped, obviously, to a certain extent. None of the three defendants gave evidence of his own. Each of them gave an interview statement. In my submission, it's perfectly reasonable for the judge, bearing in mind those factors, to deal with the matters as he did, rather than laboriously one by one. There plainly were similarities in the nature of the evidence against the three men, and indeed in the nature of their respective defences. It's important, however, to recall that the judge did remind the jury separately of each of the individual defendants' interview statements. And in particular, he reminds the jury of Evans's at length at page 607 in bundle 2. And he does remind the jury of Colebrook's evidence at page 615. So there's no doubt the jury would have well in their minds what the nature of Evans's defence was. And my lords, may I make this obvious point? This is not one of those complicated cases where it may fall to the judge, if you like, to distill the issues for the jury from a complicated set of facts, so they know what, so they don't get confused. This was a relatively straightforward case on the facts. And the judge, in my submission, succinctly did exactly what he should have done. My lords, he did also give a standard keep separate direction. That is at 529, lines 6 to 9. And in his supplemental directions, after the first summing up, at 645 to 27 to 29, he does point out certain differences between Evans's case and the others. And my lords, in particular, he does remind the jury that Evans's defence was that the police were lying. And that, my lords, you see at 612, at lines 25 to 29, 643, lines 8 to 10, and 643, line 29 to 644, line 6. So there's no doubt the jury knew, if they had to be reminded, that Evans's case was that the police had fitted him up. It was obviously his defence. My lords, my learned friend relies upon Madam Justice Appeal Crane Scott's judgment in the previous appeal. My lords, I hadn't actually expected that this would be brought up. It's not part of the respondent's case as such. But my lords, just in fairness to my learned friend, I say this: it doesn't take matters any further. But if you look at, I think, the relevant part of it, you can see a summary of what she says towards the end of the judgment. And my lords, I think it's in bundle 3. Sorry, my lords. Her judgment, I believe, begins at page 890, but there's a summary of the points that she found at page 913, paragraph 348 to 350. My lords, many of those points, in fact, overlap, but there are 1 or 2 other points. And if I can just as a way, give a few, just the bullet answers to the points that she there makes, because my learned friend is, so to speak, incorporating them by reference into his argument. It's paragraph 348 to 350. And my lords, what I say about that is this. The first point that Madam Justice of Appeal Crane takes is, first, the judge failed to protect Evans's interest by giving a timely and comprehensive direction and warning in relation to the 2 prejudicial portions of Stubbs' record of interview. Well, my lords, it's in other words, she's saying he corrected it, but too late. In my submission, the Court of Appeal, well, in their second part of their judgment, there's nothing in that. The correction was made. And my lords, on timing, can I just give you these times? The jury rose after the judge's summing up at 11 minutes past 2 in the afternoon. That's at bundle 2, 618, line 10. They were called back in for further directions at 4:24 p.m. That's 642, line 9. And then they stayed out till 7:40 p.m. That's 246, line 9. So this, it's fair to say it was 2 hours in, but they spent another 3 hours, 15 minutes considering. So it's not right to say, so to speak, the jury's mind had already been made up by then, that it was too late. Secondly, the judge says, this is 4 lines down. Secondly, having misdirected the jury as to the number of witnesses who the Crown alleged identified Evans, that's 2, he failed to retract the misdirection in a timely manner. In my respectful submission, that's a tiny point. But it is true, he did correct the point later, in his later summing up, at 645, line 22. So again, I submit nothing turns on that. And then she continues, effectively as a third point, sub-point. When he finally did so, some 2 hours later, the further direction he gave served to invite the jury to find that John Campbell had, in fact, identified Evans. Well, my lords, it may just be worth taking a look at that. I submit that's quite unfair, if anything turns on it. 645, line 22. This is how the judge puts it. Towards the end of 645, the judge is reminded by the prosecutor there was another point at line 17, and then 21. Yes, in my directions, I had told you that 3 accused men had been identified by 2 witnesses of the prosecution as being the person that shot and killed Corporal Ambrose on the 29th of March, and they have chosen not to give evidence. I'm going to correct that to say that the accused Clinton Evans was identified by only 1 person, John Campbell. There's the correction I wish to make. The point made by the Madam Justice of Appeal Crane, is that the judge then says, oh, he was identified rather than said to be identified. My lords, with respect, I submit the jury knew that inside out in any event, and there was no prejudice. The next point the judge makes is that, I think, this is 349. Next, when dealing in his summation with the appellant's records of interview, the judge effectively lumped all three of the appellant's statements together and thereby mischaracterised the contents. Well, my lords, that's just unfair. I mean, it is true at one point the judge makes the point they all are running essentially the same defence, but she reads out the interview separately, and I submit that's sufficient. And then finally, at 350, as I found, Evans's defence in relation to the firearms-related offences wasn't adequately put to the jury, and he was thereby deprived of the protection. My lords, to which I repeat the points I've already made, that there was no specific defence. He gave no evidence himself, it's that there was no serious discrepancy which the judge could seriously put to the jury as a point in his favour on whether or not he had been found with the gun. My lords, I think that deals with my submissions, unless there's anything else I can assist with.
Thank you very much indeed, Mr. Knott. Well, the board is very grateful to counsel and those who assisted them for the presentation of this complicated appeal, and we will take time to consider what advice we will humbly tender to Her Majesty. The court is now adjourned.
Thank you, my lord.